Hi there, students. In this lecture, we will discuss about the next segment that is on air pollution and the law. Well, just like the Water Pollution Act, under the Air Pollution Act, there are certain goals. Now, this particular legislation which we have in India is the Prevention and Control of Pollution Act of 1981. Now, basically, this act aims to achieve certain goals, which includes providing prevention, control, and abatement of air pollution, establishment of boards, which in fact was already established though, but the same boards, Central Pollution Control Board and the State Pollution Control Boards, have certain powers and functions under the Air Act also. This act also aims to achieve, it would rather say, confer on and assign to such boards powers, functions relating to prevention, control, and abatement of air pollution to be very specific. And in addition to that, it also lays down the standards to maintain the quality of the air. Now, this act is applicable to the entire country, the whole of India. And let's not forget that this particular legislation was an outcome of the Stockholm Declaration of 1972, the United Nations Conference on Human Environment, which we have already discussed in the class. So this act was basically passed by the Indian Parliament in exercise of its power as conferred under Article 253 of the Indian Constitution. Now, as we all know, that major problem that we face as a developing country is the presence of pollutant in the air and atmosphere. And if you look into the sources of these air pollution, there are indoor as well as outdoor air pollution sources. Indoor sources, for example, which are hardly dealt with, like for example, smoking is one. However, when it comes to outdoor air pollution, industries, vehicle pollution, noise pollution, in fact, noise pollution is something which also comes under indoor as well as outdoor air pollution. In fact, in 2010, the Central Pollution Control Board also published a report which clearly highlighted that the situation in India is quite grim because the pollution level that we have is six times higher than that of what has been prescribed by the World Health Organization. In fact, India also ranked poorly in the Environment Performance Index of the Yale Law School under the aegis of World Economic Forum. Now, when it comes to this legal framework on air pollution, this particular Air Act, so called the Air Prevention and Control of Pollution Act 1981, you will find there are certain definitions which are important from this context. But before we get into that, we should also keep in mind the Honorable Supreme Court of India, in fact, in the judgment of Subhash Kumar versus State of Bihar, has clearly held that each individual in this country, they have a fundamental right to pollution-free air, which is, of course, prescribed under, not so specifically, but impliedly under the wider ambit of Article 21 of Indian Constitution. Now, when it comes to the definition part, as I've already mentioned, the objective of the Air Act is to prevent, control, and abate air pollution, presence in the atmosphere of any air pollutant. Now, the thing is that this particular presence in the atmosphere of any air pollutant, this is what air pollution is. So the Air Act defines air pollution as the presence in the atmosphere of any pollutant. Now, what do you mean by air pollutant? Air pollutant basically means, as per the law, any solid, liquid, or gaseous substances which includes noise present in the atmosphere. So noise pollution also comes under the ambit of Air Act and in the atmosphere, and such concentration as may be or tend to be injurious to human health or other living creatures or even plant or property or environment. So it covers not just human beings but also other living creatures and property or the environment. Now, when it comes to air pollutants, it basically includes smoke, soot, heat, suspended particulate matters, fly ash, radioactive substances, vibrations, in fact, and of course, the noise. Now, this definition, in fact, emphasizes two important things we should keep in mind. First and foremost, high concentration of solid, liquid, and gaseous substances. Second component is it should be injurious or likely to be injurious to human beings, flora, fauna, properties, and environment as a large. So, small quantity of gases or even suspended particulate matter is tolerable, and it cannot be designated as pollutants until and unless the concentration of such thing reaches up to certain extent to such a volume that it becomes injurious to human health, other living creatures, environment as a whole, even property. The responsible agencies under the Air Act, of course, the Central Pollution Control Board and the state pollution control boards. The Central Pollution Control Board, in fact, comes up with this national ambient air quality standards for industrial, residential, rural, and other ecological sensitive areas. It, in fact, emphasizes on improving the air quality and prevent, control, and abate emission. SPCBs, also called the State Pollution Control Boards, on the other hand, also lays down certain standards in consultation with the Central Pollution Control Board and having regard to the air quality standards which are laid down by the Central Pollution Control Board. Now, basically, these standards are for emissions of air pollutants from industrial plants, even automobiles, into the atmosphere, and it also relates to the discharge of any air pollutant into the atmosphere from any source. However, ships and aircrafts are not covered in that. For that, there is legislation in our country. The state pollution control boards also advises the respective state governments, and their advice is quite crucial because the state government, in fact, from time to time notifies air pollution control areas only after consultation with the state pollution control boards. It also imposes certain, when I say it, it means the state government also imposes certain prohibitions in the air pollution control areas when they declare it, which of course means that there will be certain approved fuel and approved appliances, which is only permissible in those air pollution control areas. In addition to the Air Act, the Environment Protection Act of 1980 five, I believe, 1985, which no, 1986, my bad. The Environment Protection Act of 1986, in fact, defines environmental pollutant as any solid, liquid, or gaseous substances which is present in any concentration as may be or tend to be injurious to environment. And the definition of environment, in fact, also covers human beings and other living creatures and its interrelationship. The central government, of course, the Ministry of Environment, Forest and Climate Change, usually takes measures to protect the environment. It lays down, and this power is, of course, under the Environment Protection Act of 1986. It lays down emission standards, it regulates air pollution, it, in fact, also comes up with air quality standards, so called the maximum allowable limits. And as just like the Water Act, if the EPA and Air Act is in contravention, of course, the Environment Protection Act supersedes the Air Act. In addition to the Air Act, there are other provisions also in some other legislations, which of course is related to public nuisance, the tortious liability, which I believe we have already studied. Then Section 133 of CRPC, which I remember I mentioned in the class, which talks about public nuisance. Section 268 of Indian Penal Code, Section 91 of Civil Procedure Code. However, it is what we have seen the trend of the cases is now inclined towards the special legislations like Air Act and Environment Protection Act rather than these legislations, because these legislations are of course subject to certain technicalities and usually consume a lot of time. This is one of the major drawbacks with respect to these provisions, which is related to the provisions under other procedural laws as well as substantive laws. In addition to the, when it comes to the air pollution, one of the major sources of outer pollution is, of course, the industrial pollution. An industrial plant in an air pollution control area is always required to gain consent to establish an industry from state pollution control board. In fact, the industrial plant, also called the establishment, cannot emit any air pollutant in excess of the prescribed limits by the State Pollution Control Board. If they do so, then they will subject to certain penalty. In fact, the particular individual or occupier may also be restrained to function further. However, you should keep in mind one thing. If you remember, in one of the previous lectures, I distinctly, talked about Section 33A of the Water Act, which in fact empowers the State Pollution Control Board to directly issue orders rather than wait and approach the civil code for the same. Unfortunately, under the Air Act, this is not so. Under the Air Act, the State Pollution Control Board, they had to take the resort to the civil court, so-called the Judicial Magistrate First Class or Metropolitan Magistrate, and get the orders accordingly. And In furtherance to that, the court will issue directions to that particular establishment or occupier as regards certain violations which he or she might have done. This is one distinction, a point of distinction between Water Act and Air Act. Coming to some important judicial decisions that we have with respect to Air Act, one should definitely refer to the MC Mehta versus Union of India's 1997 case, also known as the Taj Trapezium case. Now, basically, in this particular case, the court observed that the emission of sulfur dioxide from coke coal using industries was causing acid rain. As you all know, that sulfur dioxide, when it's combined with the moisture, it forms sulfuric acid, which in fact leads to acid rain. And this had a corroding effect on the gleaming white marble of the Taj Mahal. Therefore, around 290 industries were ordered either to close down or to switch to natural gas. In fact, courts on various occasions have also observed that the pollution being wrongful contamination of the environment, which usually cause material injury to the right of an individual. Noise can also be well regarded as a pollutant because it is also something which contaminates the environment, which also causes nuisance and affect the air pollution. Affect the environment. In this particular judgment, also, this Supreme Court clearly applied the precautionary principle and held that the burden of proof lies upon the industrial establishment to prove that their particular establishment or industry is not causing any kind of damage to the environment. The code also goes on to the say to fact that not even 1% chance should be taken with the human health and even the prestigious monuments of international stature like Taj Mahal. In fact, it directed, as I've already mentioned, all those more than 290 industries to, either switch to natural gas or stop functioning, so-called closure.